If we have the same book, it's at page 26.
Yes, yes.
This declaration is to be found, is to be filed.
You're referring to clause 3, not related?
No, my lord, I'm on the title itself and clause 3 as well. Declaration to be made by the bridegroom and declaration to be made by the bride. The act is not gender neutral. And 3, as your ladyship rightly says, I am not related to CD, the bride, within the degrees of prohibited relationship. So bride's mother is not my relative, etc. Lord, just when your lordships are there, see the second schedule also. Just above the third schedule. The notice of intended marriage. I'm not on the legality of notice, but I'm just showing the gender issue. Your lordships gets scheduled, second schedule. It says unmarried, widower or divorcee. And for the bride, unmarried, widow or divorcee. So not only your lordships will have to rewrite the act, your lordships will have to recast even the forms, statutory forms.
Mr. Mehta, that's in para 1 also of the third schedule. What you're reading in the second schedule is
Yeah.
in para 1 of the third schedule as well.
Yeah, yes, your
Yeah, you're
ladyship.
right. वो वही आ जाता है
Widower or divorcee or lady.
Right.
Description of the party.
Yeah. Which is the next provision, Mr.
Yes. Now, your lordships may come to 19. Lord, I forgot to show, my lord, during the constitution, this parliamentary debates, one of the debate why, my lord, this act was enacted was that earlier, the previous Special Marriage Act required me to denounce my religion.
Renounce the man.
Yes, denounce my, if I get married, my lord, under this act. And that was working as a deterrent. And therefore, 19 continued, but thereafter it was taken away under 21A. That's the distinction, and that's why, my lord, I say that personal law gets re-entry through 21A. Please see 19. Effect of marriage on member of undivided family. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religion shall be deemed to effect his severance from such laws. No, two things.
Just read also, sir, 21, huh? Before we read 20.
Only kindly pause here for a minute. 19 says that persons belonging to Hindu, Buddhist, Sikhs, and Jain will renounce they would not be a part of Hindu family, but Muslim personal law continues to apply, Parsi personal law continues to apply, Christian personal law continues to apply, except in succession, which is 21.
That's right.
Yes.
Now below 20. 20 may perhaps not have much relevance. I'll just read it. Right and disability is not affected by act. Subject to provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to same disabilities in regard to the right of succession to any property as a person to whom caste disabilities removal act applies. The caste, my lord, were recognized earlier, and that there were certain disabilities which were removed. So, my lord, that rightly, my lord, in the present context, my lord, may not have much relevance. Please see, my lord, 21, where Succession Act is made applicable, Indian Succession Act, across religion, but not other personal laws of Muslims, Parsis, etc. And Christians, my lord. Not, I'm on 21, my lord,
Yes.
Chief Justice, my lord, wanted. Notwithstanding any restrictions contained in the Indian Succession Act, with respect to its application to members of certain communities. There are chapters applicable to Parsis, Christians, etc. Notwithstanding that, succession to the property of any person whose marriage is solemnized under this act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purpose of this Act shall have effect as if Chapter 3 of Part 5, Special Rules for Part C intestate, has been omitted. So, my lord, Muslims continue to govern by their personal laws,
Yes.
except in case of succession. Now, my lords, personal laws even for Hindus, which were taken away in 19, comes back in 21 because they found that this is deterrent.
Personal law, no? 21. See, the thing is for 20, 21 years, they realized that this is working
To the
Negative.
it's deterrent.
deterrent.
Deterrent. That I want to marry under Special Marriage Act, but I don't want to renounce
And
Hinduism.
eventually you might be accepted by a family
Yes.
and you are cut out. So therefore,
By law, I am cut out. The society, my family would accept me, and
but law, you're excluded. Therefore,
yes,
they brought it at par. So in that sense, there is equality among all.
correct. So, my lord, where the marriage is 21A, solemnized under this act of any person who professes the Hindu, Buddhist, Sikh, or Jain religion, which a person who professes the Hindu, Buddhist, or Sikh or Jain religion, I have to marry Hindu only. Then only 21 would apply. Section 19 and 21 shall not apply, and so much of section 20 as creates disability shall also not
So,
apply.
Mr. Solicitor, 21A lifts the prohibition or the
19.
disability which is created by 19 only where a person who is a Hindu, Buddhist,
Marries a Hindu.
Sikh marries a Hindu, Sikh.
Yes.
So if you marry outside your own religion,
You're cut out.
you are still cut off from the
19. Then 19 applies. Suppose I marry a Muslim, just giving my example.
Yes, you're right.
Then 19 would
You're
govern.
right.
21A would not.
There's one more thing, apropos your submission, to stretch it to a further extent, that 19 provides for severance only in respect of your family status, of the marriage solemnized under this act of any member of an undivided family who possesses these four religions.
I lose co-partnership rights.
Right. But there's one very important thing. So you lose your co-partnership rights. In respect of all other aspects, you are still governed by your personal law.
My personal law. Yes.
So despite 19 having said you lose your severance, there'll be a severance from the status of a family, 19 still holds intact the applicability of all other aspects of your personal law.
Correct, my lord. I'm obliged. My lord. That's the submission. My lord. Therefore, my lord, I have been respectfully urging that it may not be a choice while examining Special Marriage Act not to touch personal laws.
It's
That's-
intricately interwoven with.
It is
The
interwoven.
moment you get into 21A even,
Yeah.
or even 19, succession is governed by the Hindu law, whatever it is. If it is Hindu, Hindu law. If it is someone else there, that concerned personal law, willy-nilly creeps in.
Yes.
So section 21, 1A is
Yeah.
like that wormhole into which everything comes in.
Lord, in fact, this is a comprehensive exercise. Apropos your lordship's query yesterday, we checked up that from 52 to 54, 50 to 54, Lord, the entire debate was Hindu Code Bill, and this was a part of that very Code Bill.
And then they finally
Yes.
they bifurcated it
Thereby, yes,
into three parts.
into three parts. My lord, for Hindus, uncodified became codified, and for others, Special Marriage Act came. And my lord, there is an interweaving of, my lord, the provisions, my lord, interweaving, my lord, I'm sorry.
As they say now, there's some kind of a cognateness to these enactments.
Yes.
Cognate.
So they are all, my lord, intertwined. My lord, I'll just read, my lord.
Left.
Well, I'll give the Lord, a report, Law Commission's report, which we could find out
Yes.
yesterday
Yes.
when 21A was introduced. My lord, I'll
This is interesting.
place the copy, my lord. It is in 59th report of Law Commission of India, but they quote the select committee recommendation when 21A came to be introduced.
Do we have that in a compilation?
Is it there in volume 1?
My lord, it's not there. I'll just check, my lord, because we yesterday, my lord, tried and find out. I'll give the
It's the 59th report, huh?
59th law
59.
commission report.
Select committee.
No, my lord, law commission's report, which quotes select committee.
CSC has not filed. इसमें मिलेगा. It's Justice Gajendra Khatkar's report, huh?
Yes, yes, my lord. No, it's not there, my lord. I'll, my lord, place it within 10 minutes.
All right.
Allow me to
Just
read.
read it.
In the documents folder.
Volume 10.
Mr. Solicitor, just read it out. It will be a short, one paragraph.
There is one paragraph, my lord.
Just read it, that's all.
Why 21A was brought in. It may not be necessary to shuffle through, my lord. I'll just read, my lord. In our opinion, that the select committee says, in our opinion, it is desirable to exclude from the scope of this section cases where both the parties are Hindus. In such cases, the law of succession, otherwise applicable, should continue to apply. We see no reason why the fact that the parties choose to marry under the Special Marriage Act should make a difference in such cases, i.e., where both are Hindus. We recommend that such cases should be excluded from Section 21.
Oh, I see.
Yes. But the reason was, Lord, registration of a marriage has never been compulsory. Even today, it is not compulsory. It's a personal choice, whether it is under the Special Marriage Act or under the Hindu Marriage Act or under any other marriage act.
But it does not make it valid if you don't register. Correct me, I think it is compulsory, but failure to register does not render the marriage void or an irregularity.
Compulsory.
Maybe, my lord.
Has not-
Depends. But,
Hindu Marriage Act, it's not compulsory.
Compulsory, is it? No?
It's not.
And what is
but my lord, the deterrence was,
Yeah, that is meant for registration.
Lord, there were many marriages in those days when this 21A came, which were solemnized.
You can inquire from across the people in the court, how many have many marriages.
My learned senior says these marriage is not registered.
Same here. Same here.
Where is the proof, Mr. Dwivedi? Where is the proof?
He'll raise our hands.
No, we
If I'm not wrong, I think this compulsory requirement of registration of marriage was introduced a few years back when they
Yeah,
said
recently.
even if you are married according to Hindu law or any other thing, you must register your
My
marriage.
lord, earlier what used to happen, the marriage would be, my lord, solemnized as per Hindu rites, Saptapadi, etc., not under Special Marriage Act. But I want a certificate of marriage. Therefore, my lord, it became a deterrent that if I take certificate, I'll not be governed by Hindu Succession Act.
Right.
I think one state used to, it used to be
State provision,
compulsory.
there is no
You know,
national.
There is
because
in
of
Tamil
8.2,
Nadu.
because of section 8.2.
Yeah.
8.1 says the rules may be made, but 8.2 says that the state may make it compulsory.
Yeah, yes.
But it
Tamil
also
Nadu.
says that if you breach it, it will be only punishable with 25 rupees.
Yeah,
It does not affect the validity of the marriage.
correct.
80% of marriages in the villages, they're not registered at all.
Absolutely, you're right.
Tamil Nadu, I think, made it compulsory,
It is socially.
if I'm not wrong. Mr. Datar, I think
Relatives collect. and then
Absolutely.
it's known.
Ordinarily.
Tamil
Mr.
Nadu, it became compulsory
But
because
then-
of that form, no, self-respect marriages. Swayamvadayam. So that was made, I think,
Right,
section
yeah.
7A or something was enacted.
Otherwise, you have to take evidence of, show your wedding photograph album.
And if you require a visa, if you require a
Certificate
visa,
from the
you
Pandit.
require a marriage certificate.
Only Visa investment.
Visa another thing.
Marriages could be solved.
My lord, therefore, section 15 came. Section 15, my lord, is registration of marriage is solemnized under other laws. You can still get a registration, which may not be governed by
15 of the
registration.
Hindu Marriage Act.
No, my lord, Special Marriage Act, Section 15.
That is, of course, there.
Your lordship has Section 15.
Yes.
Yes.
Any marriage celebrated, whether before or after the commencement of this act, other than a marriage solemnized under the Special Marriage Act or under this act, may be registered under this chapter by a marriage officer in the territories to which this act extends, if the following conditions are set is fulfilled: the husband and wife, etc., etc. So, my lord, if there is a marriage as per Hindu rights, not under Special Marriage Act, I can go and get it registered, my lord, under Section 15.
In other words, if notice, the notice mode is accepted, then the registration itself is a marriage ceremony.
Yes,
Itself
it's a
is
marriage certificate, but
Itself is a marriage
Yeah.
ceremony.
Just go to the and get yourself registered. Yeah. And interestingly, see how well that section is worded. Section 15 says any marriage celebrated.
That's right.
So celebrated
Not
would mean
solemnized.
anything, not solemnized, celebrated. You have celebrated the marriage. You
Well,
invited 20 friends,
recently,
you
my
have
lord,
celebrated
Mr.
them.
Datar told me that a week before, the marriage was 2-minute affair, I think. He attended a marriage, my lord, in Chennai.
It's called self-respect marriages.
That's all.
That's all. No other.
And then you can get it registered here.
I think if lordship says Hindu has a 8A or something section where they have.
7A, I think it used to be there.
Amendment.
The Tamil Nadu amendment, no? Yeah.
I think it's the second shortest, in this.
Yes, 7A, Tamil Nadu.
After section
Swayamvar.
7A.
Yes, but that's a Tamil Nadu amendment, man.
That's
Yeah,
in
Swayam
60s, I think
Varithai,
the first,
Swayam Mari Yathai marriage.
I
That is
think it was
Swayam.
made in the 60s, right?
68.
68.
Yes,
The first government of,
after the DMK government.
yes. after the
1967, with effect from 20th January 68.
Even came, my lord.
Tamil Nadu.
Yes.
Please.
Lord, please see Section 18. Why this was a deterrent and 21A had to be brought in. My marriage is solemnized as per Hindu rights or as per Muslim nikah right, whichever way.
Interestingly, 15 also uses the expression husband and wife.
Husband and wife. Well, there's more than once, my lord, they are husband. For example, my lord, your lordships may see 12. 12 proviso, last, my lord, last line, lawful wife or husband. Well, but there's several, my lord. I'm not reading everything because there are several places. My lord, but 18
Their
says,
contention, of course, was wherever it's husband and wife, treat it as spouses or person.
yes, my lord, that
But your contention is that that's not enough. You will have to, because there are so many other interlanguages which you can't then.
then you will have to restructure or redesign
It's
or
not, according to you, just a question of reading the expression person for husband and wife or just spouses or for husband and wife.
Yes, my lord. Now, my lord, please come to the divorce. And there is some, my lord, substantial ground on that. Divorce, my lord, Section 27. Subject to the provisions of this act, I'll not read everything, my lord, because the contents are not relevant. The purpose is different, my lord. The subject to the provisions of this act and to the rules made thereunder, a petition for divorce may be presented to the district court either by the husband or the wife on the ground that, Lord, these grounds are available to both husband and wife. Correct, my lord? Now come to 1A. I'm not reading the grounds, my lord, it's not relevant for the purpose. 1A. A wife may also present a petition for divorce to the district court on the ground that her husband has, since solemnization of the marriage, been guilty of rape, sodomy, or bestiality, that in a suit under section 80 of so and so, 125 of CRPC, so and so, a decree or order, as the case may be, has been passed against the husband, awarding maintenance to the wife, notwithstanding that she was living apart, and that since passing of such decree or order, cohabitation between the parties has not been resumed. Now, my lord, the answer to this was by the other side that let both have both the grounds for divorce. But as I recollect correctly, Lord, when this was pointed out, that there are separate grounds available to both, and 1A applies only to wife. So who will be the wife in a man-man marriage, in a woman-woman marriage, or in a man transgender or woman transgender marriage, or two transgender marrying? Who will be the wife? The answer was that they would both have both the grounds. Now, my lord, there is a problem. And the problem is, can your lordships read a statute which gives one additional ground of divorce to one class to the detriment of heterosexuals for which the Special Marriage Act is enacted? So there would be a class within the class. If I am heterosexual, I will not get as a man the grounds under 1A. Otherwise, wife also can be guilty of rape, bestiality, etc. But if it is a same-sex couple, 27 would apply differently and both would be available, my lord. That would be not, my lord, a correct way of interpreting statute, my lord. Applying one section in one way to one class and differently to the class for which the act is enacted.
Yes, Mr. Solicitor.
Lord, please come to page 31, section 31. Court to which petition should be made. This is again not reconcilable. Section 31. Your lordship gets, my lord?
Yes.
Section 31, my lords. My lord Justice Narasimha gets, my lord.
Yes, yes.
Every petition under chapter 5 or chapter 6 shall be presented to the district court within the local limits of whose original jurisdiction marriage was solemnized. Respondent at the time of presentation resides. Parties to the marriage last resided together, or please see 3A. In case the wife is the petitioner, where she is residing on the date of presentation of the petitioner. In case of a gay marriage, who will be the wife? In case of a lesbian's marriage, who will be the wife? In case of a transgender marriage, who will be the wife? These questions will arise. And my lord, we cannot leave it just that in individual cases, they would be taken care of. Across the country, this would arise. Lord, now kindly come to section 36. Alimony pendant light. Your lordship gets, my lord? Lordship, yes, 36. Where in any proceedings under chapter 5 or chapter 6, that is judicial separation or divorce, it appears to the district court that the wife has no independent income sufficient for her support and the necessary expenses of the proceedings, it may, on the application of the wife, order the husband to pay to her the expenses of proceeding and weekly or monthly during the proceedings such sum as having regard to husband's income, it may seem to the court to be reasonable. Now, my lord, if your lordships were to read person applicable to all, then, my lord, right of a non-LGBTQ wife will be taken away because then husband can also claim alimony from her.
Just come again.
My lord,
But that's
The-
happening in heterosexual marriages too, Mr. Mehta. That's I mean, we've all come across it at different times in our jurisdictions where the husband also claims.
but here only wife is given right. Please read it again. From the husband. My lord, may I, Lord, slightly rephrase this? My lord. It says, if the wife establishes that she has no means of income,
Right.
she can apply, and husband is under an obligation to give her maintenance pendently. Now, my lord, first of all, there cannot be any decision by the court who is the wife in same-sex relationship. I'm not elaborating, my lord. But if your lordships were to read person instead of husband and wife, correct? So one person will be entitled to claim maintenance from another person, meaning thereby, in case of heterosexual marriages, to which this act applies. In fact, it applies only to them, according to us. A husband can also claim maintenance pendent lite from wife.
And
Heterosexual wife.
alternately, if it is interpreted to read as person only in the case of a same-sex marriage, then there will be a distinction between same-sex and heterosexual couples.
That again,
Because in the case of a heterosexual couple, the husband cannot claim maintenance under 36. But in the case of a same-sex couple, we would be reading it in such a way that either spouse can claim it from both.
but one of the men can. If he claims that I am the wife,
Oh, it depends. Yeah.
he says I am the wife, or in a lesbian couple, one of them says that I am the wife.
Depending
Because
on
one of the arguments
orientation.
made was if you identify yourself with that
That's the
role.
orientation.
Orientation, role was the word used.
Role was
that
the
I
word
play the role
Right.
of a wife. And which court, my lord, how can the court decide what is true?
That will
Suppose
become a preliminary issue.
it would,
That will become a preliminary
Jurisdictional issue.
it would be. My lord, therefore,
issue.
and
It's maintained.
That's an impossible.
and again, my lord, fundamental.
That inquiry, to say that who
Apropos your ladyship's my lord, remark, your ladyship is right. Under section 24 of the Hindu Marriage Act, that permits both husband and wife
Wife to
to claim,
either party to marry.
yes,
That's why we've come across in many.
we lordships come across, because 36 of this act restricts only entitlement to wife.
Why?
It was a progress, in that sense, it was a progressive enactment.
Yes.
It went beyond because it recognized that
It could be a husband.
Any
who's-
one of the two
could be one
spouses
of
could
the
be
two.
destitute.
Even
But they-
section 124 CRPC
I was just going to
entitles even parents to claim
Yeah.
maintenance. Parents, children, etc.
of those things came because of amendment.
In Muslim law, my lord, it's different again.
For 125, the obligation is straight on his wife, neglects to maintain his wife.
Your
His
lordships are on
legitimate or
125?
illegitimate, 125.
125, my lord, yes.
His legitimate or illegitimate minor child.
His wife, unable
His
to
legitimate or
obtain
illegitimate
or
child. His father or
legitimate
mother.
illegitimate children, his legitimate or illegitimate child, his father, mother, etc.
125 don't apply to women.
That's again is restricted to.
But 24 per se talks of husband or wife.
Yes,
Any of
yes.
the two.
Either way, my lord, if wife is more, my lord, has more means of, my lord, income, etc.,
Strong.
then husband can also, my lord,
That's right.
claim maintenance. Now, my lord, last section, 39A, Special Marriage Act. I'm not, my lord, troubling your lordships any further. 39A, enforcement of decrees and orders. All decrees and orders made by the court in proceedings under chapter 5 or chapter 6 shall be enforced in the like manner as the decrees and order of the court made in exercise of its original civil jurisdiction for the time being are enforced. Lord, I'll show there are separate provisions in CPC for execution for male and for female. Sixty-one. 61. Lord, now,
Mr. Solicitor, therefore, looking at the conspectus of these provisions, perhaps we can conceptualize your argument by saying that reading the provisions of the Special Marriage Act, and if the court were to make an effort, as the petitioners say, to reinterpret the provisions, there would be three major problems. One, it will involve substantial rewriting of the legislation. Two, it may also involve the court ignoring some provisions which have been introduced as a matter of public policy, as we saw the additional grounds in the case of a woman for divorce. And third, it would involve reinterpretation of personal law, because there are segments of the Special Marriage Act which specifically contain a reference to the personal law. So there is no way in that, the third category, there's no manner in which the court can avoid the interface between the Special Marriage Act and
personal
law.
And I'll respectfully add the fourth, that court would not read any statute so as to make it applicable to one class differently and another class differently.
Court cannot adopt a dual approach.
I let's check. I didn't follow that.
So philosophy permits.
Yes.
Yeah,
And
right.
and my lord, there are several questions, my lord. Some of the questions, my lord,
Mehta, just to clarify, 39
Everything
once
is one.
more.
Everything is not one.
Mm.
Our philosophy.
Lord, and in with the ingenuity of lawyers and litigants, my lord, it may not be a far-fetched idea, my lord, that a heterosexual couple can come and say that now apply me the provisions which you have read for LGBTQ, because we may be heterosexual, but internally well, we are not. I feel different way, etc. I don't wish to elaborate any further, but it opens room for several my lord, complications which your lordships cannot conceive right now. So
Will you-
now,
Will you repeat yourself on what you were pointing out in section 39, appeals from decrees and order? What was the
Our
point you were making?
core of our philosophy.
Section 39.
39A, my lord, the decree will be executed as if it is decree of the civil court under civil procedure.
Right.
And I'll show there are separate provisions for male and female under the CPs.
We can't read.
Mail it to Mr. Mail it to the solicitor.
Solicitor.
Yes, my lord. Now I'll just quickly, within 10 minutes, 15 minutes, show your lordships, my lord, how other provisions would become unworkable. Quickly, just illustratively, please come to my first note yesterday file, my lord, page 61.
Just 1 second.
My lord, it is note 1. It's a submission on the question that only legislature can deal with. That's, my lord, the title. Yesterday's note, my lord.
Yesterday's note.
Note
Page
one.
61, that is 64, PDF 64.
Just 1
65,
second,
I'm sorry.
PDF 64, note 1.
God, not 1, PDF 65.
ये कहाँ गया है?
Yeah, yes.
Petitioners.
Lord, now
Para 112,
114.
114.
Next page, my lord, maybe a little.
Yes. No, you had read up to 113.
Yeah, yes, ma'am. But 114. I'm not going to read the whole.
What's
I'm
the
just giving
PDF
the
page?
flavor of other provisions, which will be affected, my lord, which are not before your lordships. Now, my lord, Indian Succession Act undisputably applies.
Yes.
My lord, Indian Succession Act undisputably applies to all except Hindus. Hindu would be governed by the Hindu Succession Act. In a given situation, if he marries Hindu, otherwise Indian Succession Act. Now, this also, my lord, kindly just 1 or 2 sections, just for the flavor. Domicile acquired by woman on marriage. By marriage, a woman acquires the domicile of her husband if she had not the same domicile before. So it will have to be decided who is the woman. Wife's domicile during marriage. A wife's domicile during her marriage follows the domicile of her husband. For passports, etc., this issue would arise and you will have to decide who is the wife. I'm not reading all, but my lord, Succession Act provides for widow, widower, husband, wife, father, mother, etc. Well, just highlighted part also, if you can, lordships can read. 33A. A widow but no lineal descendant and the net value of his property does not exceed the whole of his property shall belong to the widow. Now, my lord, if in this relationship one partner dies, whether he leaves behind a widow or a widower, then, my lord, your lordships may see 43 at the foot. In the intestate's father is dead, but the intestate's mother is living. Now, my lord, next generation. My lord, marriage is permitted, they adopt, and someone dies. And father and mother is, my lord, LGBTQ couple. Who will be treated as dead as father and who will be treated as dead as mother? This would be the, my lord, dilemma and can't be, my lord, foreseen by your lordships. Now, please come to 115 and quickly, my lord, I'll take your lordship through the flavor of, my lord, other 160 sections which will be affected. Though they are not arising here, my lord, for your lordship's consideration, but inevitably they would be affected. They are not in question, they are not for interpretation also. But the moment your lordships reads the word person, in case of man and woman, wife and husband, these are the consequences which will follow. Just, my lord, highlighted part, and I'll read only some sections. I'll skip remaining section. Please see 1. Section 3G, degrees of prohibited relationship, your lordships have.
Where are you?
Sorry,
Where are you reading?
Lord, I'm sorry, page 115 of
Page?
my yesterday's.
Yeah.
We were looking at
Yeah,
Even I was looking at that.
115.
No, I'm sorry, my lord, page 115. My apologies.
Mr. Solicitor, what PDF page is it?
It was 119, lords.
119, right, Hindu Marriage Act
Yes.
on the top, right.
You are giving us PDF pages by asking your junior. You are supposed to give us PDF pages by having your own.
No, my lord, I have
open.
calculated it is +4. So it's a simple formula, my lord.
Mr. Solicitor, I'm putting you on notice. For this matter, fair enough. Now we have exempted you, you know. But we are not going to read down the statute in the next matter. You have to have your iPad open. You're not going to be looking at Tanu and asking him to give you pages next matter.
I am already in.
Get ready and.
My lord, I am already.
Otherwise, we'll ask your junior to argue. We'll ask Tanu to argue.
Yes.
Only he who has or she who has an iPad will argue.
Solicitor, see, the Chief Justice has enforced this norm on me, so you can't escape the norm.
No, nobody. My lord, I am already under a continuing mandamus and I am already in breach.
And the norm is applicable even at Tughlaq Road, you see, because Justice Paul is away from the courtroom, and yet he's. I really appreciate that because Justice Paul picked it up for the first time in this matter, and he's completely, absolutely felicitous now. Justice Bhatt, of course, has been doing it since Delhi High Court days.
No, my lord, your lordship, I did one constitution bench, my lord, fully on iPad. My lord, I'll even next time, my lord, in this matter also, I'll be on the iPad. I can, my lord, assure your lordships. My lord, please come to 119. My lord, this is Hindu Marriage Act, which the same parliament, the same legislature, using some word, my lord, in different statute is presumed to know the same meaning. Lord, section 5(3), Roman 3. The bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. Lord, same section 3, bridegroom and bride. Then your lordships may only see, my lord, punishment for bigamy. Or please see, my lord, section 19, item number 8. Court to which the petition shall be presented. 3A. In case the wife is the petitioner where she is residing on the date of presentation. Your lordships may, my lord, come next, my lord, page 121, PDF 121. I'm skipping rest, my lord. Hindu Adoption and Maintenance Act, my lord, applies to me. I can adopt, my lord, if I have married a Hindu wife. If I marry Hindu wife, my lord, under the Special Marriage Act, Hindu Adoption and Maintenance Act would apply. Section 12, capacity of a male Hindu to take in adoption. And 13 is capacity of a female Hindu to take in adoption. You'll have to necessarily be having different eligibility to adopt a child. Because if it is a man, he cannot adopt a girl child more less than 21 years of difference. If it is a female, she cannot adopt male child. So it can never become gender neutral. Then, my lord, 15 is maintenance for wife. 16, maintenance of widowed daughter-in-law by the father-in-law. Lord, suppose in a same-sex couple, one of them dies and the other claims against the father-in-law that in our relationship, I was the daughter-in-law. I was the wife and therefore your daughter-in-law. Impossible, my lord, to decide that fact. That is something, my lord, in abstract, no court can decide that. It has to be, my lord, a biological woman or a conventionally known biological woman. My lord. Then dependents are also defined in 17, my lords. A, from the estate of her husband, and B, from her son or daughter, if any, or his or her estate. Then, my lord, Hindu Succession Act. Your lordships have, my lord, indicated already, I'm not reading it. If a female Hindu dies without making a will, there is a separate list of succession. Class 1, class 2, agnates, cognates, but class 1, class 2 changes. And this is, my lord, applicable under section 21A of the Special Marriage Act. There is no dispute. If a male Hindu dies intestate, then there is a separate list provided. But there also, if a male Hindu dies intestate, wife is in class 1 heir, widow is in class 1 heir. Whether in case of a same-sex couple, one of them dies, the second can claim as a widow or not. Hindu Succession Act will have to be, my lord, suitably amended. Then natural guardian, my lord, Hindu Minority and Guardianship Act applies because of 21 Act. If both are Muslim, both are Hindus, both married people are Hindus. Kindly see A. The natural guardian of a Hindu minor in respect of the minor's person, as well as in respect of minor's property, excluding his or her undivided interest in the joint property are, in case of a boy or an unmarried girl, the father, and after him, the mother. So you'll have to decide who is the father. There is no difficulty as of now because it is not tried to be made gender neutral. And we know father means a particular attribute, mother means a particular attribute. Similarly, my lord, your lordships can, my lord.
Solicitor,
Please, your lordship.
to test it as a devil's advocate,
Yes.
can it be said that under all these provisions, the biological sex at birth is what is to be taken into account, as the purpose is only to facilitate a marriage of a gay couple? Can it be said? I'm putting a question to you.
Yes, my lord, my answer is this, my lord. First of all, if we go by the intent and purpose of the legislature, the intent and purpose is that the legislature always thought of biological conventional man and biological conventional woman in consideration. Second, even if it is ignored, it will not become workable for the simple reason that when it says that widow will inherit, in same-sex gay couple, who will be the widow? They may say that I'll not claim, but all same-sex couples are not here. They cannot waive their right on behalf of the entire community. And it can never be decided on a case-to-case basis, my lord.
Be dependent on the other.
Yes, completely, my lord. And court also cannot decide, my lord, if someone dies.
Yes, please.
Yes, Mr.
Yes. Look, these are all interlocked laws. My lord. Personal laws are interlocked. It's like a jigsaw puzzle. You can't remove one block and my lord, replace it with something. Then the entire picture changes.
So you want us to see any other statutes here? That's it there.
Yes, but I'll just give illustrate. This is again an illustrative list, not an exhaustive list.
Right. The next now is your Hindu Minority and Guardianship Act,
Guardianship Act, my lord.
Muslim Women Protection of Rights.
Kindly, my lord, see the last section 29 on that, my lord, at
20.
page 125. Section 6, custody of minor children. This is for Muslims. Again, my lord, man, woman, but kindly see 29. Notwithstanding, and I'm sorry. Anything contained in any other law for the,
125.
I'm sorry. Yes. PDF 125.
Yes, we got it.
Yes,
Section 29 of
right.
Muslim Women Protection of Rights of on Marriage Act 2019. 29. Notwithstanding anything contained in any other law for the time being in force, a married Muslim woman shall be entitled to custody of her minor children in the event of pronouncement of talaq by her husband in such manner as may be determined by the magistrate. So the custody goes to mother. It will have to be decided who is mother. And mother means, Lord, the way we understand, Lord, the way Parliament has understood. Lord, then your lordships can keep Parsi Marriage Act again. Parsi man means husband, and Parsi wife means woman means wife, my lord, etc. Christian Marriage Act, similar provisions. But please come to 129.
You know, Mr. Solicitor, talking of the Parsi Act, I mean, just as an aside, this is probably the only act where the jury there's a jury trial.
Yes.
So as single judges of the High Court, and I've sat presiding over a jury trial in a Parsi matrimonial dispute. So you have jurors who will advise you on the on facts. And most of these trials, you're very distinguished members of the community who come and attend and take their work extremely seriously. You might have a top surgeon in the city who has decided
They
to
come
give
as
that one
jury
day.
members.
They come and sit and as jury members in the.
Lord, please come to page 129. I'm just, my Lord, suffering. I'm not reading all. Please, my Lord, read it at leisure. I have highlighted that part which is, my Lord, making it impossible to reconcile, my Lord, if the way they want the Special Marriage Act to be read is in fact read. So section 57. My Lord, this is Christian Marriage Act. Separated wife deemed spinster with respect to after acquired property. The spinster and bachelor has its own meaning, my Lord.
Highly objectionable. This language needs updating.
Mr. You have to amend the act, Mr.
My
Solicitor.
Lord, this is,
Spinster
your lordships are
and
right,
all these things, what-
1872. 1872.
Time to update ourselves.
Your ladyship, my lords are right.
Deemed spinster.
Then, my lord, your lordships, may, my lord, kindly come to Lord, page 139, Dowry Prohibition Act. But, my lord, that is read, my lord, that both can invoke. No, I'm sorry, Domestic Violence Act is, my lord, can be invoked by both.
Yes, yes, that's important.
139,
139.
yes. Penalty for giving or taking dowry. Please see, my lord, 2A. I'm not reading the whole, because it's not necessary, your lordship.
No, no.
You come to the domestic.
That's at PDF 137.
No, my lord, 139, my lord, if your lordship.
39 is dowry.
139 is
37
dowry.
Yes, Dowry Prohibition Act.
We thought you were referring to
I
the
think you
domestic.
please turn to 137.
7, DV Act.
TV Act.
Yeah, yes,
134.
Lord, but DV Act, my lord. Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. The respondent means any adult person, it can be father-in-law, etc., brother-in-law, any adult male person who is or has been in a domestic relationship with the aggrieved person. Lord, I did not read this because possibly, my lord, this court had, my lord, a
No,
year
but
or
then
two.
See, look at the proviso. That
Proviso is aggrieved
actually
wife or
point
female living in a.
relative of the husband
Yes.
or of the male partner. Therefore, that's where the sisters, I mean,
Mostly that's how-
surviving sisters-in-law, and mothers-in-law, they all come in like.
All are coming, and even brother-in-law,
Yes.
uh,
Relative.
So proviso expressly applies to a heterosexual relationship.
only. Yes. And, my lord, Dowry Prohibition Act, my lord, 2A. Nothing in subsection 1 shall apply to or in relation to presents which are given at the time of marriage to the bride without any demand. And, my lord, then it says bridegroom without any demand. So again, my lord, what is contemplated is heterosexual couple.
What is the Dowry Prohibition Act?
Page
Page
138.
138.
Lord, 139, my lord. 138, I'm sorry.
Which provision was solicitor reading? Mr. Solicitor,
Lord,
which-
106, section 1, Lord, item 106, section 3 of the Act, 2A. Your Lordship gets, my lord?
marriage to the bride.
Marriage.
Nothing in this subsection 1 shall apply or in relation to 1A, presents which are given at the time of marriage to the bride without any demand having been made in that behalf, provided that such presents are entered in a list maintained in accordance with the rules made under this Act. Presents which are given at the time of marriage to the bridegroom without any demand having been made in this behalf. So they also, my lord, mention bride and bridegroom. My lord, kindly now turn to, my lord, just as an illustration, my lord, my lord, Indian Penal Code. Man and woman are defined under section 10, my lord, 140 at the foot. Section 10. Lord, your lordships, man, woman, the word man denotes a male human being of any age. The word woman denotes a female human being of any age. Then 114, my lord, for example. And my lord, when 1954 Act came, this definition was in existence. The legislature knew what is the meaning of male and female. Well, then section 100 and well, item 114, section 304B, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death.
So suppose a lesbian woman in a relationship.
Even 376 will not apply in the case of same-sex couples who are males.
My lord, 375, if your lordship sees at page 142, it applies only to males. And please see, my lord, I'll not read. A man is said to commit rape.
142, is it over here?
Yes, my lord, page 142, section 375, definition of rape. Because only man can be guilty of this offense, my lord.
A man is said to commit rape.
And further, my lord, a man is said to commit rape if he so and so,
Right.
He meant something else. If a man, and here I'm not talking of same-sex relationship. If a gay man rapes another man, it is not rape.
IPC, this is that.
that would be 377,
7.
which is, my lord, now which goes.
No, no.
No.
Without consent is there. Yes, yes.
But then
Still consent,
Yes,
377.
yes, yes, yes. It is, I stand
I
corrected.
think there is a change in the there's a
377.
difference in the
Expression.
course definition, but even the penalty also.
Yes. Your lordship, it's only consenting same-sex people. my lord. Yes.
is 10 years. And all the other, amended provisions which have enacted gang rape,
Some women,
370 on women.
Right.
Now, there can be equally same situations on men
men
also.
also.
They are completely, inapplicable.
But in case of lesbian marriage, my lord, possibly this may not apply, possibly. No, my lord, it may apply if we read man to be woman,
Disparity.
375 B.
Right. Definitionally, it is.
B. If we read man as woman also, then it may apply. Otherwise, the intention is to punish man. That's how it.
Was a definition of.
Yes. Otherwise, a woman can be guilty, my lord, under B or maybe under C. Not similar is abatement provisions, abatement to suicide under the Evidence Act. If a woman commits suicide, there is a presumption against the husband.
Right.
So again, my lord, we will have to see, my lord, who the person is. But the major problem is in Code of Criminal Procedure. My lord, page 144. Arrest how made. Now take a homosexual couple, both man, but one playing the role of a woman. Arrest of how many? Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class, within whose local jurisdiction the offence is
Because in
committed.
a case of a what else, Mr. Solicitor, now after
Yes,
this
Lord.
was
Lord, last, Lord, I am not taking a lordship, Lord, I have given 160 such similar provisions, my lord. But, my lord, if your lordships can come to 147, my lord. When it is decree and decree is to be executed, even under the Special Marriage Act, my lord, therefore I pointed out section 39A, that decree of judicial separation or will be executed as. There also, my lord, the word is female, male, husband, wife, etc., etc. My lord, I am not duplicating. Your lordships can, my lord.
I think we can conclude this part of the analysis.
My lord, there are, but again, my lord, even if illustrative list is 150 sections of various other statutes.
All-
So therefore, my lord, in my respectful submission, your lordships may not give the meaning, my lord, which creates complications then solving the problem. My lord, maybe if Parliament considers appropriate, Parliament may, in its wisdom, my lord, provide for a comprehensive legislature. And as I have pointed out yesterday, wherever other legislative bodies have done it, they have suitably amended other allied laws as well.
All right. What is the
Maybe by the amending act or by one act, my lord, whichever.
Now,
way.
what is the next point?
Now, my lord, next is Gaidan.
Next
Kindly
point?
come to page 78.
Gaidan, okay.
Gaidan.
Yes, yes.
Which page?
My lord,
Volume?
82.
The other part.
For the same.
Page 82.
कहाँ पर है गैतन?
82. Here it is.
lordships need not read.
Yeah.
Page, I'm sorry.
Same note one.
Note at this stage, your lordships need not read. I am also not reading. Page 63 to 82, I have produced relevant parts of the judgments which says that in the process of interpretation, your lordships would not interpret contrary to the intent, would not change the structure, would not tamper with the architecture, etc., etc. These are the
All right.
propositions are well settled. I'm not, but these are the page numbers.
You
Now,
also
please,
quoted, quoted Lord Nichols,
yes,
quoted Lord Nichols
yes.
extensively.
Extensively, my lord. Because that still continues to be a leading judgment on, my lord, how, where the process of interpretation ends and where the procession of legislation begins. Lord, 78. Lord, I'm sorry, page 82, PDF 82. Lord, the significance is, please, my lord, consider this. In Britain, your lordships are aware the House Parliament is sovereign, it's supreme. There used to be no judicial review the way we understand it, to declare a provision to be unconstitutional. What they do is non-compatible, incompatible. That's how, my lord. That was introduced, my lord, by way of Human Rights 1998 Act. Gedan, my lord, in my respectful submission,
Yes.
yes, my lord, kindly, my lord, allow me to read this, my lord, Gedan, because the reliance is misplaced. Without giving the background and the context. Please see, my lord, further. Apart from the absurdities that the said principles as canvassed by the petitioner may lead to, it is necessary to also settle the issue raised through the judgment of Gedan. It is submitted that reliance on the said judgment is wholly irrelevant to the present case for the short reason noted as under. The system of judicial review in UK and the system of judicial review in India are starkly different. Prior to the enactment of Human Rights Act 1998, there was no judicial review of legislation in UK. Specifically, Section 3 of the HRA 1998 empowers the UK domestic court to reinterpret or force through treaty obligations under the European conventions in local statutes. In Gedan, the court was dealing with an entirely different subject matter of an enactment dealing with rent and not of creating a social institution in the nature of marriage. It was a question of a singular provision to be read in consonance with the treaty obligation and not the case wherein the entire architecture
Yes, please go.
Lord, Gedan was not dealing with, my lord, an interpretation which affected several multiple statutes. But now see the difference in powers available to the court, my lord, in UK and in India, my lord. A bare perusal of HRA, which for the first time in UK provided something akin to judicial review of legislation, would make it clear that the said legislation and our constitution operate very differently in terms of mode and the result it seeks to achieve. The relevant provision of HRA are as under. My lord, then one I can skip. Kindly directly come to 3 at page, my lord, 83. Interpretation of legislation. This is a kind of judicial review which is available, my lord, in UK, which is complete, my lord. Therefore, they say that Supreme Court of India is the most powerful court of the world, because your lordships can strike down the provision also as unconstitutional made by the competent legislature. Interpretation of legislation. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the convention rights. But so far as it is possible, it's not a mandate of law. This section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation, or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation, or enforcement of any incompatible subordinate legislation if, disregarding any possibility of revocation, primary legislation prevents removal of the incompatibility. You declare it, nothing beyond that. It continues not only on the statute book, it continues to operate also. That, my lord, comes in further sections. Declaration of incompatibility. Subsection 2 applies in any proceedings in which a court determines whether a provision of primary legislation is compatible with a convention right. If the court is satisfied that provision is incompatible with a convention right, it may make a declaration of that incompatibility. Subsection 4 applies in any proceedings in which a court determines whether a provision of subordinate legislation made in exercise of power conferred by primary legislation is compatible with a convention right. If the court is satisfied that the provision is incompatible with a convention right and that, disregarding any possibility of revocation, the primary legislation concerned prevents removal of incompatibility, it may make a declaration of that incompatibility. A declaration of that, this section, under this section, a declaration of incompatibility, please mark, does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. It's kind of an advisory jurisdiction. It's, as they say, my lord, jurisdiction to nudge the legislature. And, my lord, I have also pointed out that after Gedan, even the courts in Britain have taken, my lord, different view, my lord. Now, your lordships may kindly see in Gedan, my lord, para 148, I have quoted Lord Nicholas. In this context, kindly read, my lord, my learned friend said that now after Gedan, whatever you want to read, you can read into the provision and even alter the statute. That was, my lord, the tall argument which was made, which is, my lord, how legally not sustainable, but the foundation is false. The foundation is that there is an equal jurisdiction between the Supreme Court of India and the UK Supreme Court. UK Supreme Court exercising power of declaring a statute to be incompatible, nothing less than that, my lord. 147, if your lordship don't mind, if your ladyship don't mind. 84, yes. My lord. It is submitted that despite the wide powers, the court in UK have clarified that the powers are limited, interpreting, not legislating. Even post-Gedan, we can only interpret, we cannot legislate. In considering that is what is possible, the courts have repeatedly stressed the constitutional importance of maintaining the boundary between interpretation, which is, this is in quotation, my lord, McDonald judgment, subsequent to Gedan, interpretation which is a matter for the courts and others who have to read and give effect to legislation, and amendment which is a matter for parliament. This is post-Gedan McDonald judgment. Now, Lord Nicholas in Gedan. Parliament, however, cannot have intended that in discharge of this extended interpretative function, the court should adopt a meaning inconsistent with the fundamental feature of legislation. This was not read before your lordships in Gedan by the petitioner. In Rent Act, Lord, the essential feature is not whether the marriage is heterosexual or homosexual. It was rent and the provisions concerning that. that would be to cross the constitutional boundary, section 3(6) to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger and Aylesbury, go with the grain of the legislation. My Lord, in my respectful submission, this changes the scenario. In Special Marriage Act, grain of the legislation is heterosexual marriage only. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Then Lord Reger, my Lord, your Lordships may, my Lords have, my Lord Justice, in same, my Lord Gedan, my Lord Concurring. What excludes such provision from the scope of Section 3(1) is not any mere matter of linguistic form in which Parliament has chosen to express the obligation. Rather, they are excluded because the entire substance of the provision, what it requires the public authority to do, is incompatible with the convention. The only cure is to change the provision, and that is a matter for Parliament and not for the courts. They, like everyone else, are bound by the provision. Kedan says this, which, my Lord, was not assisted with, my Lord, by the petitioner to your Lordships.
Actually, you can see the last portion of that.
Lord,
Report, page PDF 85. 85.
Yes, my Lord, 80.
The last
Yes,
highlighted.
for that is impossible. Yes, my Lord. May I read, my Lord, the first part also? It does not allow the courts to change the substance of the provision completely, to change a provision from one where Parliament says that X is to happen into one saying that X is not to happen. Then, my Lord, bold portion at the foot of this para. For instance, the Court of Appeal held that I'm sorry. It was impossible for the court to use the interpretative obligation in Section 31 in effect to recreate the fixed penalty scheme enacted by Parliament so as to turn it into a scheme that was compatible with Article 6. As Simon Brown, Lord Justice, observed, it would have involved turning the scheme inside out, something that the court could not do. Only Parliament, not the courts, could create a wholly different scheme so as to provide an acceptable alternative means of immigration control. This is the ratio of Gedar. Now, your Lordships, may allowed to kindly see para 149.
He uses stronger words like judicial vandalism.
My Lord, I didn't read it, my Lord. In fact, my Lord, this is still, my Lord, British language. American judgments are more harsher.
Very sharp.
Very sharp.
Very sharp, my Lord. Very.
Because they are not always career judges, you see, in the American Supreme Court. They come from public policy backgrounds, from academia.
They use even sarcasm.
And Justice judgments are extraordinarily trenchant.
Justice Kalia. Justice Kalia. Lord, Justice Kalia in this, my Lord, Oberfläche has used sarcasm, my Lord, while dealing with further judgment. But, my Lord, that.
Yeah, absolutely.
Lord, para 149. Judicial vandalism, Lord, I avoided reading that part, my Lord, but it's not, my Lord, I'm just only reading, my Lord. It is submitted that discussion of the boundary between legislation and interpretation has tended to focus on two factors. First, it will not be possible to construe legislation in a convention-compliant way if to do so would be inconsistent with some important feature of the legislation. The grain of the act, my lord, as they say. And grain is heterosexual, right from the debates till the language used. Secondly, the courts, even in UK, have shown a reluctance to place creative reliance on Section 3 in cases involving complex questions of social policy, which the courts are ill-equipped to decide and which are therefore best left to Parliament. The earlier authorities prior to Gedan and after HRA, which were summarized by Lord Brigham in so-and-so versus so-and-so, it was held that a convention-compliant interpretation may not be possible where it would be incompatible with the underlying thrust of the legislation, or would not go with the grain of it, or would call for legislative deliberation, or would change the substance of a provision completely, or would remove its pith and substance, or would violate a cardinal principle of the legislation. My lord, this is before Gedan and after the Human Rights Act, my lord, came into effect. Lord, kindly, my lord, come to the next page, my lord.
Yeah, Gedan was 99.
Gaidan was 99,
99.
so the Human Rights Act came into force in 1998.
98. And this judgment, my lord, no, Gaidan is 2004, I'm sorry.
2004.
2004, my lord.
It's after the act.
It's post-act.
So between 98 and 2004 comes, my lord, this Sheldrake, Justice,
But the interesting part is that concurrently with Gaidan, you have that Civil Partnership Registration Act in 2004,
Four.
around that time. So there was a move there.
yes, my lord, contemporary move. But that was discussed, debated in public, and thereafter brought by way of a legislature, my lord. And Gedan was not concerned with that issue, my lord. On the subject matter before Gedan was not that issue. Then, my lord, after Gedan, Wilkinson judgment, my lord.
This
Yes.
is also very interesting.
May I, my lord?
We'll continue after that.